Coming up, I want to introduce Marcus Heyder, who will then introduce his panel. Marcus is well known on the international privacy circuit, having gone from the Federal Trade Commission to a think tank called the Centre for Information Policy Leadership, and he pops up all over the world. Marcus, the floor is yours.
Thank you very much, John. And let me grab a bottle of water while I wait for the panelists. Do we have enough for everybody? Actually, we don't. If there's any more water bottles, that'll be very helpful. I think we would need only one more. There's two more.
I'm going to answer a question for Gihan. Oh, no, it's gone. Charles has knocked it out. Gihan was asked on the Ask vote, do you think there's any chance of a social credit system being developed for New Zealand? And I'm going to say on his behalf, no, hell no.
I didn't quite get to this, but we shouldn't be too complacent, John, because the other research that some of my colleagues are doing has shown that this kind of thing is happening at the micro level in companies. And I meant to ask the person from Facebook, but we've heard of Facebook having its own reputation score or trustworthiness score. But companies are increasingly around the world starting to rate their customers for how trustworthy they are, quite apart from their financial creditworthiness. So I think it's already happening throughout the world in terms of what businesses are doing.
I'm filling in the space. I'm not making more. Can we have the panel up here? Angelene, thank you. Thanks, Gihan. Thank you, panelists. Marcus, do you have a panel?
Yes, my panel is coming up. And
so we've done a tour du monde. We've been to the US, we've been to the UK. Marcus, over to you.
Thank you very much, Sean. Maybe we'll start because we have limited time. We have 45 minutes for four commissioners and representatives of data protection authorities. And, sorry, I don't know. So we're going to get started right away. I will try to stay out of it as much as possible, but I do just want to make a few remarks. It feels like we already spent a whole day here, but we only spent a little more than 2 hours, but we've covered so many topics from all across the world. It was very interesting, but now we're going to focus on some of the priorities from 4 important data protection offices in the Asia-Pacific region. And this is your opportunity to ask any questions you might have of these 4 authorities. We're going to start with introductory remarks by each one of them for a few minutes, 5 to 8 minutes, and then hopefully there'll be questions from you and some discussion if there's time left. So very briefly, we'll start with Angelene Falk, who is the Data Protection and Information Commissioner from Australia. And Angelene is going to talk about the new Australian notifiable data breaches scheme that commenced earlier this year, and I think is very relevant for New Zealand because I understand that New Zealand has a similar proposal pending, so it would be very interesting to hear from Angelene about Australia's experiences in the first few months of that data breach notification scheme. Then we'll move on to Rachel Dixon from Victoria in Australia. Rachel is the Deputy Information and Privacy Commissioner there, and Rachel will talk about end-to-end encryption breaking, which is a very hot topic. And I saw earlier in the question feed, a few people already asked about it. We didn't get to those questions, but it's a very hot topic, so we look forward to that. And then Raymund Liboro, who is the commissioner in the Philippines, of the National Privacy Commission in the Philippines, and he's going to address a few of his office's priorities, ranging from consumer complaints, the APEC cross-border privacy rules that the Philippines is working towards, data breaches as well, and a range of priorities for his office. And then finally, we'll get to Kosuke Kizawa, who is Deputy Director at the Japan PPC, and he is going to talk about the role of the APEC cross-border privacy rules that Japan has incorporated as a legal cross-border transfer mechanism within its privacy protection framework. And that's actually a very important topic also for other authorities here. As I mentioned, the Philippines are working towards joining the CIPL system. Australia actually just announced the fact that it was accepted into the CBPR system, so we might get to that as well from the Australian perspective. So a lot of interesting topics, and I think we're going to go through the 4 presentations first and then turn to some questions. And please ask questions on your Ask Vote app if you can. So Angelene, please go ahead.
Thank you, Marcus. Thank you very much, and thank you to Commissioner Edwards for the invitation to be here today. We've had 2 days of wonderful discussion of this very important issue of data protection and privacy. Commissioner Denham described it, I think, earlier today as a year when privacy became mainstream, and certainly that's been my experience in the Australian context. Coming into this position at the end of March this year, the Cambridge Analytica matter occurring, and also the start of the Notifiable Data Breaches Scheme in Australia, and also the GDPR, together with a number of government programs in Australia that attracted significant community interest. We have a new digital health system that requires citizens to opt out if they don't wish to have a health record. We have a new national digital strategy. There's been a number of developments in terms of law enforcement initiatives, the increased use of biometrics and so on. And all of that has led my office to have an emphasis on how we increase transparency and accountability in handling of personal information. And that theme cuts right across the functions of my office, not only with data protection, but also in relation to access to information, increasing transparency of government decision-making by providing access to government information, and increasing representative democracy through the exercise of those functions. The Notifiable Data Breaches Scheme that came into operation at the end of February this year in Australia is one of these statutory mechanisms to increase transparency and accountability. And given New Zealand has on its books the likelihood of such a scheme, I thought I could give you some of the learnings that we've experienced in regulating under that scheme. The tests for reporting notifiable data breaches have some interoperability globally, but there's also some differences. In Australia, the application of the scheme is broad to all agencies of the federal government, and also for organisations that have a $3 million turnover or more. But not all breaches are reportable, and there's a particular test that needs to be met in order for the breach to be reportable. So there needs to be an unauthorised disclosure or use or loss, but the critical issue here is that under the Australian law there's an opportunity to try and reduce the risk of harm occurring. And if you're successful in doing that, then the breach is no longer reportable. The test is that it's likely to result in serious harm to one or more affected individuals. And I note that the New Zealand bill, the test there, is focused on a breach that's caused certain harm, or there's a risk that it will do so. So potentially a lower threshold of reporting than under the Australian law. There's some differences in terms of timeframes for reporting under the GDPR. Obviously, it's a 72-hour timeframe for reporting if it's likely to result in a high risk of adversely affecting rights and freedoms. Under the Australian law, there's an opportunity to assess the nature of that risk, and then once your suspicion is confirmed, then you need to report to my office and to affected individuals as soon as practicable. In terms of the volume of what we're seeing in notifiable data breaches, I've produced 3 reports so far since the scheme came into operation, which gives some statistical analysis. The numbers are not as high as what the European data protection authorities are seeing, but they're still significant from an Australian point of view. Under the voluntary scheme, we received 114 notifications last year. This year, you'll see per quarter, we're around the 245 mark each quarter. So 550 since the scheme commenced at the end of February. And you'll see that the top sectors are health and finance, and that seems to be a consistent trend. Perhaps not unexpected, given that the Australian Privacy Act covers all healthcare providers, regardless of size, and the finance industry, of course, being an industry that holds significant amounts of data. I'll give you a snapshot of some of what we're seeing in terms of the causes. And this is a really rich source of intelligence, both from a regulator's point of view, but also from the regulated community's point of view. So from my perspective, the notifiable data breaches that come to the office give us an opportunity to ensure that we're focusing on preventing data breaches, also the rectification and containment and the remedying, and how we can increase the security posture right across the economy as a result of what we're seeing. So you'll see here that the main cause is malicious or criminal attack, but that can include theft of hard copy documents as well as cyber. But human error is also a significant cause. And if we break that down a little bit further, you'll see that in terms of cyber matters, compromised credentials is the top reason for data breaches, and significantly phishing is the key cause. So what we see right across the breaches that are reported is this element of the human factor that's present. Either it's human beings sending the wrong email to the wrong address or the fax machine, or it's clicking on a phishing email. So we really need to be going back to basics in terms of password strength, in terms of ensuring multi-factor authentication, but also the training of staff and ensuring that the systems and processes that are in place within businesses support good decision-making around handling of personal information. The numbers of individuals affected are primarily under 100, but of course some of the online cyber breaches affect more individuals than that, up into the millions. In terms of the information affected, contact details is the most common, but also financial details and identity information. In terms of some of the quick lessons, if I can capture them in 4 points, I've talked about the need to reduce the risk of human error, and that's, I think, very important for New Zealanders to consider in anticipation of a scheme coming into place. But also to ensure that you've designed and implemented an effective data breach strategy. Ensuring that in terms of your contractual arrangements with data processors, that you have a clear understanding of reporting obligations. And lastly, the need to avoid data breach fatigue. So ensuring that you are looking at the threshold tests for reporting and ensuring that it is those matters where individuals need to be notified that are being brought to their attention. As a regulator, one of the key issues that we have found is the need to work collaboratively. So not only with our cybersecurity counterparts within government, but also global regulators and right across the EU in terms of the one-stop shop and the process that's in place to identify lead DPAs for dealing with these issues. A couple of examples of the page-up matter that involved many countries around the world, and we've been able to collaborate with the ICO in relation to that matter. The Cathay Pacific matter that a number of the DPAs here have dealt with has also been a matter dealt with by my office. So thank you.
Thank you very much. So turning to Rachel, as I said, we'll take questions after all the speakers have given their initial presentations.
Thank you, Marcus. And once again, thank you also, John, for hosting. It's a very, very interesting couple of days. I was going to talk about end-to-end encryption, but I'm specifically going to talk about the Five Eyes push, I guess, to modify end-to-end encryption. In Australia, you may have read here that we've been having lots of discussions. The government has floated the idea of a bill called the Telecommunications and Other Legislation Amendment (Assistance and Access) Bill 2018. It's called that because it actually amends 7 other acts, and there's a contingent amendment of another act, basically taking powers that have already been awarded in other areas like interception, telecommunications access, various other things, and then essentially providing capabilities to break the ability of encryption to impact on those things. This is something that many intelligence leaders in the Five Eyes groups and law enforcement chiefs have said is a barrier to their work. We completely understand that. The reason I'm talking about this is while this bill is a Commonwealth bill and I work for the state of Victoria, one of the peculiarities of my Act is that I actually have specific oversight of law enforcement. Part 5 of my Act says that I actually govern the use of all law enforcement data and systems. And Part 4 of my Act allows me to actually set standards for security for all government agencies. And just before I took up my commission, that was harmonised so that the Victoria Police, for example, are obliged to follow exactly the same standards as the rest of the Victorian state government. So I have a very specific interest in this because under the bill that's proposed, Victoria Police will end up using some of these tools. Now, when the government first floated the intention of doing this, a lot of people in the tech industry said this is a very bad idea, and the laws of mathematics say that if you break encryption, it's going to be terrible. And our former Prime Minister, we have a lot of Prime Ministers, former Prime Minister famously said, the laws of mathematics are very commendable, but the only law that applies in Australia is the law of Australia, and I bet he didn't wish he didn't say that. Now, why it's interesting, so the UK attempted a bill, well, in fact, did pass a bill in 2016, which was the UK Data Protection and Investigatory Powers Act 2016. The UK and the EU obviously have more rights protections. Australia has no Bill of Rights. And so I think the reason for driving very hard in Australia is that this is it's an interesting place to do this. The bill itself provides for 3 mechanisms for the government to request or compel companies to act on behalf of the government. They can issue a technical assistance request, they can issue a technical assistance notice, or they can issue a technical capability notice. The notices are mandatory, which is an interesting compulsion. They did do a bit of a strategic retreat, I think, the government, because in when they finally got to introduce this bill, having gone through the laws of mathematics debate a little while earlier, they had listened a little bit to this. And so there's by the way, the clause numbering is horrendous in this bill, but clause 317ZG1 says that the bill shall not have the effect, any of these things, the notices, or shall not have the effect of requiring a service provider to implement or build a systemic weakness or a systemic vulnerability into a form of electronic protection, or preventing a designated communications provider from rectifying a systemic weakness or systemic vulnerability in a form of electronic protection. The problem with this is that nowhere in the bill is systemic weakness defined. And this has been, I guess, there's a parliamentary committee currently hearing submissions on this. I would say that a lot of the submissions are very well drafted. The bill has been through several iterations now since that committee first began sitting, so there's been quite a few changes. And there is currently a fairly active fight going on. This is the first national security initiative, I think, in Australia since I can remember, where the Coalition and the Labor Party have split on whether or not it's a viable bill. Not necessarily the purpose. I think everybody wants the purpose, which is to enable law enforcement to have more access, certainly all parts of government. But industry disagrees as to whether or not this is actually practicable. Today, in the Australian, if anybody reads the Murdoch press, the head of the Australian Criminal Intelligence Commission basically said it's pretty much a take it or leave it bill. It's a holistic look at things, and it's impossible to divide out various bits of the bill and say that's good and that's bad. It's ironic because the one thing the bill is not is a holistic view of security. And I say that ironically because in this systemic weakness debate, one of the things that from the people in the intelligence services and law enforcement who've given evidence before the inquiry and are talking about these things, it is clear that there's an element of magical thinking. And the element of magical thinking is that you can have let's take a completely hypothetical example. I have a device, I want to break the encryption on the single device, just the end user device. And whatever capability I put in place, whether it's by weakening certificates or whether it's by actually putting malware on the device or whatever it is that I'm legally entitled to do, you might say, well, it's only that one device. That's not systemic. Well, that would be true if, having paid, for example, the device manufacturer to manufacture the tool, I then destroyed the tool. But the bill has no such compulsion. And the existence of that tool, one of the things we know from, for example, national security is that state actors routinely stockpile zero-day exploits, and it's it's a powerful thing that they have going for them. Law enforcement, not so much. It's not really one of the things that they do. But this would effectively give law enforcement a locker of tools. Now, there's nothing to prevent the device manufacturer from subsequently, after the terms, if there was a warrant, for example, after the terms of the warrant, from releasing a patch to make that vulnerability go away, or that they won't get paid for doing that, by the way. They'll only get paid with no profit margin for doing the first one. But it certainly raises the issue that, for example, I could see a future where Victoria Police may end up with a toolbox of 20 or 30 really handy-dandy tools, which they will never want to let go of, for good reason, because it will aid them in the prosecution of various things. Not the detection, interestingly, but the prosecution. But can I just say now that I am not, as a regulator, that comfortable that Victoria Police's security systems are sufficient to prevent those tools from leaking into the wild. And at that point, the existence of those tools themselves represents a systemic weakness. Now, the government disagrees on this. The government would hold that this will be very secure and will take the maximum possible steps. As a regulator, I will obviously take a very strong view on the security of those things. The trick is, though, that all of this is being done in secret. The government has recently introduced some changes to allow companies who are compelled to report on the number of compulsion requests they receive in a 6-month period. This is a new thing in the most recent version of the bill. But they will not have the ability to say what they were for, what they did, or which agency requested it. One of the things we've learned in the telecommunications metadata bill, which is a prior bill which you may have come across, where the government can compel telcos, for example, to keep all of the IP address ranges and various other metadata around telecommunications, is that we've seen that power extended to way beyond law enforcement to, for example, local councils to catch litterers. We don't know that it was extended to councils to catch litterers, except that the councils have told us that's what they did it for. If you, in a company, reveal the existence of one of these things, and there's a good reason, by the way, for secrecy. You wouldn't want to tell everybody that you all of a sudden had come upon a handy-dandy tool to turn every phone into a listening device, for example. That would be a bad thing to let. That would be like, hackers, come here and please steal this capability. So you want to keep it secret. But it presents unusual challenges for us as a society and the tech community in general to have a view of what the vulnerabilities in our ecosystem are. And that itself is a massive systemic weakness, particularly because the Attorney General, under this proposed legislation, will get to be the determinant of what is reasonable and proportionate. He may seek expert advice, but if these things are all being assessed in an individual context, it's this one tool for this one purpose, you would say, well, that's reasonable and proportionate. This is a very bad person. We must catch them. If, however, you look at 15 vulnerabilities that have been created, and the only person who gets to do that is the Attorney General, because nobody else can talk about it and there is no other oversight, then that becomes very problematic. Companies can appeal this now to the federal court, the Federal Circuit Court, although their ability to do that in public, of course, is obviously very limited, and they won't be able to talk about what it is that they're appealing in any meaningful sense. But there'll be no reporting to the public to say, well, we've caught this many bad guys, or we've done this, or this was a powerful capability we leashed upon the world and it's being used for good. And I think that lack of oversight. One thing the UK bill, which was found by the UK Court of Appeals to be a breach of human rights, but the one thing it did have was the creation of a commissioner who oversaw the operations of all these things. And the fact that the Australian bill doesn't even go that far, so that there's nobody with a view of whether or not this is actually working or not working, or whether it's actually being used properly, I think is a significant oversight. So basically, to sum up, because I'm running out of time, but to sum up, we have three views that as an office that we think is, this is a bad thing. And the three things would be, we think it's not proportionate, effectively, that it's an unnecessary and disproportionate impact. This extends to websites. I mean, this extends to, if I was The Guardian, for example, and I wanted to receive anonymous tips, I could compel The Guardian to basically build a tool that enabled me to access all those tips. right? So these lockers that journalists have set up. The Parliament of Australia recently realised that this would have a chilling effect on parliamentary privilege because ministers may not be able to receive, or members of Parliament may not be able to receive whistleblower tips securely. So they were a bit unhappy about that. We think it's disproportionate. The uses of the bill, of the current powers that government have not been necessarily, so the metadata piece is not being adequately exploited. We think that they probably could do some more with that. And we think that the systemic weakness one is just insoluble. Interestingly, the government has not found a single tech company. The Law Council of Australia is very unhappy. Outside of law enforcement and the intelligence services, they have not found a single group that thinks that this is a wonderful thing. So we will be continuing to watch it. If it doesn't get through the House, if it doesn't get through the Senate in the next 2 weeks, it will be pushed into next year, and we'll see what happens at that point.
Well, thank you very much, Rachel. And now Raymund Liboro, please, from the Philippines.
Thank you, Marcus. Thank you, Angelene. First, I'd like to congratulate Commissioner John Edwards for assembling this formidable cast of thought leaders on privacy. I do not consider myself within their league, but I must admit they are all my mentors. I'm saying this because the Philippines DPA, the National Privacy Commission, is actually considered the Benjamin when it comes to data privacy and protection, meaning the youngest. And our law, though established or enacted in 2012, is only 2016 that the commission was actually formally organized. So we're barely 3 years. And and just to segue, and I'm supposed to talk about data breaches and how we manage them. But even as a young DPA, we are not exempted again from all these global breaches that's happening. And the mere fact that there are so many Filipinos around the globe, more or less, whenever a big company gets hit by a breach, there's a Filipino that's or whose data is involved. And by way of describing some of the features of our law covers all Filipinos wherever they are. But it also covers you if you are within the Philippines, and if the processing happens within the Philippines and your data was compromised, then you can be assured of our protection and our support. So we started in 2016, but in 2017 we already announced and built a little bit of awareness for people to complain, and we got numbers. But if you look at it significantly, what I'm trying to show here is that from that time to this year, is that complaints have grown fourfold. And when we talk about personal data breaches, in our in the second year, we had 60 breaches that was reported to us, and it has grown fivefold. Like Australia, not all breaches are reportable. So we have certain categories of information that when breached need to be reported to us. But we have, again, separate provisions for that. But just to show you, again, so many cases have landed on our laps, and I think one of the more, it's actually the first case that we handled is our own Commission on Elections, where 77 million records of Filipinos were exfiltrated and dumped in the dark web. But we have Uber, Paul Financial, Facebook, and we've been talking about this, like Cathay Pacific. So we, as a commission, we have to attend to this, and the people and Filipinos expect us to come out and do something about this. So, our law, as many of your consultants might have already told you, is quite punitive. Concealment of a breach involving sensitive personal information is punishable by imprisonment and actual fines. We haven't sent somebody to prison yet, so don't be the first. But anyway, again, I've got nothing to do with this law. It's a law that we have to implement. But I remember this saying by former U.S. President Theodore Roosevelt: "Speak softly and carry a big stick," and he will go so. And what we've been doing is actually speaking softly to our stakeholders and telling them their obligations, approach regulatory in a different way. So we're kind of, sandbox to the regulatory approach, where we emphasize more on giving advisories, information, support, and dialogue. The first thing we did was actually conduct a national survey of the awareness level of Filipinos when it comes to protecting their data and also privacy. Obviously, it's a very low base that we're coming from. So we thought that, we have to really, actually teach our people about their rights and also teach companies about their obligations. So yes, we do carry a big stick, but we approach it softly with our industry and stakeholders. So it's very important that early on, they get to understand also our stance and also our approach. And yes, our law is so scary enough that we had to tell them, here, we're here to provide you with support. And we're treating you more as partners rather than adversaries. And for some reason, it's clicking, it's working among our industry. But more importantly, we tried to keep our messaging simple. So what we did was issue what we call the 5 pillars of accountability and compliance. So if you're a company operating in the Philippines, all you have to do is observe these 5 pillars, meaning you have to commit to comply by appointing your accountable officer, or what we call a data protection officer, know your risks, and conducting your risk assessments. Third would be being accountable by creating your privacy management program. And fourth is demonstrating this accountability by, again, doing it within your company. And lastly, again, being prepared for a breach. So these, I think, are very simple, logical steps any company could take in trying to comply with the Philippine law. So much so that we took an industry approach. So what we did was, again, talk to the associations, and brick by brick, we're building this, promoting this framework with all our companies, but again, reminding them of their obligations. I remember landing in Sydney, and the customs says that you just declare it, right? So what we're also telling you, if you have a breach that falls under the provision for reportable breach, just report it. And we've done, I think this has also gained traction among all the companies. We were talking of 20 companies. So what we do is that each industry sector is, we can try to consolidate them by touching base with their associations. So, and we assign them numbers. In case of DPO1, we're talking about the government sector, DPO2, the telecoms. We're now at DPO 20. It's the tourism sector. But it's also, it's quite wonderful to see companies working together. For example, in the case of the pharmaceutical industry, they have 2 rival associations within the very lucrative pharmaceutical industry. But for the very first time, they joined forces to be able, again, to promote privacy compliance within and among their industry members. So having said that, again, Marcus mentioned about our plan to enroll in the CBPR, because what we did, again, of course, the CBPR has always been on the plate when we got on board. But right now, with our industry approach, the voices are now coming from businesses and industry, and now they're clamoring to join the CBPR. We could have done it 2 years ago by imposing it and telling the industry to, hey, we'll just enroll the CBPR and just have to follow. But right now, as their awareness increase, they're also seeing now the benefits of upping their game or bringing their game to the next level by seriously looking now into the CBPR. And in the future could be EU adequacy. And by that time, we're quite confident because we have created our industry support from the base. So the NPC would, I hope, will be well in its way on implementing a truly responsive operation and accountable ecosystem, privacy ecosystem in the Philippines. Thank you.
Thank you, Raymund. And now finally, Kosuke from Japan, PPC.
Thank you, Marcus. And hello, I'm Kosuke Kizawa, the advisor to the head of office of international affairs at PPC Japan. And Commissioner Edwards, thank you for giving me this opportunity. And I'm honored to speak among distinguished delegates and guests. Today I'm going to talk about the PPC Japan's activities in the Asia-Pacific region, mainly the APEC CPPR framework. And first of all, for those who are not familiar with the PPC Japan, let me briefly introduce about the PPC, Japan's Data Protection Authority. The PPC is an independent organization established based on the Japanese Personal Data Protection Law, or APPI. The PPC consists of one chairperson and 8 commissioners, highly independent, appointed by the Prime Minister. And the PPC has about 140 officials. And as you can see here in the slides, our mission is personal data protection to protect individuals' rights and interests. But at the same time, we have to pay due regard to the benefits from utilizing personal information. And promoting international cooperation is one of our important missions we are supposed to carry out as specific operations. And here's a brief description of major international initiatives of the PPC. In the Asia-Pacific region, we are promoting the CDPR system, which I'm going to talk soon. Meanwhile, with regard to the EU, as you might know, Japan and the EU is to build framework for mutual and smooth personal data flows. The EU is going to give an adequacy decision to Japan, and Japan is going to designate the EU as a permitted area for data transfer. Also, in light of the Brexit, we are to ensure continued smooth personal data flows between the UK and Japan. As you can see, the PPC has multiple approach to ensure safe and smooth data transfer globally, which puts us kind of a unique position in the Asia-Pacific region. Now, let me describe a brief history of Japan's participation in the CPPR. We participated in the CPEA, or Cross-Border Privacy Enforcement Arrangement, in November 2011 to promote cross-border cooperation among DPAs in enforcing data protection laws in the APEC member economies. After that, Japan participated in the CBPR system in April 2014. And in January 2016, the JIPTEC, a non-profit organization to ensure information security and personal data protection in Japan, was approved as Japan's accountability agent. And so far, 2 companies were certified so far. Yeah. And here's Japanese legal description of personal data transfer to a foreign third party. By Article 24 of the Japanese Data Protection Law, data transfer to a third party in a foreign country is only permitted if a foreign country or region is designated by the PPC as having sufficient level of data protection, or if a third party has a system in accordance to the standards set by the PPC, or if there is a consent from the data subject. And the CBPR certification falls under the second category. And this is a list of the PPC's initiatives to promote the CBPR system. We are the members of the AASG, Accountability and Administration Study Group, that is an APEC's governance mechanism to sustain the CBPR system. As an outreach activities, we have provided a leaflet to invite business operators in Japan into the CBPR system. Also, we organize a series of seminars and workshops in Japan and abroad. More than 26,000 participants have joined the seminars since 2016. And recently, we organized a CBPR workshop as a side event in the ICD PPC in Hong Kong last year. And from now, I'd like to talk about the reason the PPC is trying to promote the CBPR system. And first is practicability. The Asia-Pacific region is one of the most diversified area in terms of legal, cultural, and historical backgrounds. CBPR is suitable to bridge different legal systems to protect personal information. The second is global standard. CBPR can ensure the baseline of data protection in line with the OECD privacy guide principles on which the Japanese Data Protection Act is also based. CBPR could improve business operators' practices in handling personal data because it gives business operators an opportunity to assess their policies and rules for handling personal data. Some companies consider the CBPR as a first step to establish their BCR. And third is economy. We think that the CBPR system could make the Asia-Pacific region one of the largest areas of safe and smooth data flows. And let me turn to the DPA's perspective for the benefits of the CBPR. This could be applicable to many DPAs. And first is an enhancement of the level of protection. The more companies are certified with the CBPR, the higher the level of data protection will be. This is because the accountability agent confirms that the certified company is compliant with the APEC privacy framework and also the domestic laws. Therefore, it can be expected that the level of data protection by the certified company will be improved through the review of the accountability agent. And second is effective remedy. In Japan, those who intend to become accountability agents are required to become a so-called accredited personal information protection organization. The accredited organization shall formulate the personal information protection guidance and supervise the member entities to comply with the guidance. The accredited organization also handles complaints from consumers against the member entities. This will facilitate effective remedies. And the third is vitalizing economic activities. With the certification of the CBPR, the level of protection for the company will be predictable, as the company is certified to be in compliance with the APEC privacy framework. The existence of such certification would increase the reliability as a business partner. They could be engaged in business activities with confidence. That is an important environment for a robust economy. And finally, effective enforcement. Through CBPR certification, the PPC could efficiently collect necessary information from CBPR certified company, since the data protection management of the company has been strengthened through confirmation by the accountability agent. Consequently, it is expected that when the company has been certified, it will facilitate an effective enforcement by the DPAs. As for business operators, by obtaining CBPR certification, they can establish a system to promptly provide information required by the DPA when we request reports or conduct on-site inspections. Therefore, this could be an advantage for business operators too. And the coming two slides explains what I have just talked. And now I have talked about the initiatives we have been taking to promote the CBPR system. However, we are still on the way to go because we have few certified companies under the CBPR system in Japan. We are supposed to increase the number of CBPR companies to realize an area for safe and smooth data flows in the Asia-Pacific region. In order to do so, we'd like to conduct more of promotion activities, and we are going to conduct dialogue with business sector and to know about the bottlenecks or the hurdles. And also we are going to do cooperation with DPAs in other APEC member economies to promote the CBPR system in the Asia-Pacific region. Thank you.
Okay, thank you, Kosuke. So the question is, John, do we have a few minutes or do we need to wrap up now?
I don't know. It's ticked over to 5 o'clock, so we're starting to intrude into people's evening time. There may be people wanting to go home. I'm going to thank you and thank the panelists. If there are pressing questions, please join us for a drink afterwards.
Okay.
Thank you, Marcus.
Thank you very much.